Abusua mo call about the Over Daily Update TV. So now I will show you my day na subscribe to my YouTube channel, no subscribe no like no share, na odo commenting so as your comment section. Ya beje bre na ya kan wait for na hwefo nyina so bi. Chachuchu kata, sorry. Supreme Court and Speaker Alban Bagbin ensem na etwagu. Na eno na Kelvin Taylor akasembi. Asema o kan say expertise application a Afenyo de ba court no enye draft enye endorsed application because there are some wrongs and errors bi o de buyer because we expertise no de buyer na enye ade a endorse ye endorse anu de buyer into one enti sorry aye speaker a lawyer no e catch a Supreme Court judge they say even application a Afenyo market the buy no applications are enye endorsed a drafted application enti no Supreme Court no anya fast and checks ye because anko ye fast or like or checking in ye ya anka ensem no emedru ha one because ensem expert application era Afenyo markets the buy no there's a lot of mistakes and I say enye applications are ya endorse ebusia yenko na yenko tika Kelvin ensem na oka no etino na just Supreme Court no kra be tum say Afenyo markets application is scandalous like also omujitum to ombedia tumudi also omujitum because lawyer of a speaker amoma we say application na Afenyo de buy no expert application no drafted and endorsed and there is errors in it because speaker declare 4 seats vacant. Afenyo so far is a 3 seat abusia na just say in all no I will say the Supreme Court and I say Chief Justice admit say there is a serious wrong in what there is a wrong applications era Afenyo edibay so obedia tum dia because sorry legal team Emma speaker amana say the expert application wrong wrong abusia yenko nengo tinsam.
It is endorsed to say the previous meeting has been endorsed to be an official or valid document. Afenyo Markin took a draft document that has not been endorsed by Parliament into the document Afenyo Markin took to the Supreme Court. Not sad document, and yet they're in the final document of Parliament. Sorry, or yes, Speaker of Parliament, the lawyer and the Supreme Court is on a half case or on a half truth. What Afenyo Markin brought was not even an endorsed document from Parliament. It was a draft. And Afenyo Markin came here to say things that were not accurate because Speaker of Parliament ruled on 4 MPs. He did not rule on 3 MPs. So it is scandalous for the Supreme Court of the land to say they are ruling on a half-truth, on a draft, on a document that is not totally official or endorsed by the Speaker. So Afenyo Markin is just bringing a sheet of paper to come to Supreme Court to go get a ruling. And then Speaker of Parliament, lawyer and catcher Supreme Court said, this is not right. You are not supposed to do that. It is scandalous. A whole Supreme Court cannot get its facts right. And another judge in the case of Kasa. Now, I didn't know also say it is scandalous, but the facts are the facts. How many MPs in the Parliament? 4 MPs were the MPs are speaker really almost so how did it happen say in Parliament in Supreme Court we are talking about 3 MPs. Now let's move forward. Now this is also another thing that happened. Speaker lawyer raised the issue be that the ruling of the court is based on parliamentary proceedings that has not been approved by the speaker. Now, so study pa. Even the next day, now Speaker by they still did corrections in Parliament on the previous meeting. Previous meeting now Afenyo Markin ejina so called Supreme Court The next day, I speak about Parliament, they had to correct some things in the previous meetings. So Afenyo went to the Supreme Court with a document that was a draft that was not an endorsed document. And it's in a Ostadia. Parliament the next day, you saw the speaker forcing Parliament, the clerks there to make corrections to their previous meetings.
Speaker, thank you for the opportunity. Mr. Speaker, item number 5.
Supreme Court to say, the guy, you will even listen to him, ex-party application, the document he brought are not documents that were adopted and endorsed. So you see what they were doing. This was the day after Alban Bagbin took that decision. The next day they came, they called something a vote and proceedings. What they do is they sit, and what they do is they correct every single thing in the previous proceedings. Whether there was some votes cast or whatever they decided on, they come back before Parliament's new session starts, they correct everything. The moment they are doing that moment, the activities that happened the day before are just a draft. It has not been adopted. So what they will do is they will adapt before. When they finish doing all these corrections, they will now adopt it and endorse it. Then it will be part of parliamentary records. So Afenyo went to court with documents that had not been corrected, documents that were just drafts. And Ekache Supreme Court to say, the guy, you will even listen to him, ex-party application, the documents he brought are not documents that were adopted and endorsed. So in the first place, it is scandalous for the Supreme Court to be ruling on a document that has not been adopted and endorsed. That is what the lawyer was saying. Meaning, in the first place, we were not even supposed to be here. If the Supreme Court had done its job, if the Supreme Court had done its due diligence, if the Supreme Court had taken its time not to make this whole thing an ex-party process, if the Supreme Court had taken its time to allow the other part or other party to also bring their grievance, the Supreme Court would have known that Afenyo's documentation that he presented was a draft document and that it wasn't a document that has been adopted and endorsed. In the first place, the beginning of this whole thing was scandalous. The Supreme Court, which has the oversight responsibility to make sure, say, every document that comes before Osonomame and her battalions, those documents have gone through the litmus test. Those documents are legit and factual. The documents before them, which they ruled on, the documents were half-truths. But the court said they don't care. The Chief Justice, and then Mekache Ghana for say, upon all the law they have learned, let us use common sense here. And common sense, Obia Onkanu Krebiano, there are two things they don't want to apply: common sense and paying attention to details. They deliberately ignore details because the moment they try to pay attention to details, they will see say they are corrupt. And that is what is happening at the Supreme Court. The Supreme Court deliberately ignore details because when they decide to take care or monitor or pay attention to details, Afenyo will not have a case. In Afenyo and the Chief Justice, and the Supreme Court itself, it is not even ready to open it as itself up to make sure detailing or making sure the facts are true. They don't care because they are in a rush to rule for a corrupt minority leader, Afenyo. Because so we a judge now to want to say an opposing lawyer raise the issue here. It goes against the integrity of the court. You are supposed to protect the integrity of Ghana Supreme Court. And what you do is that you call for a detailed document. I didn't know a lawyer and say, why don't you provide us with a real document from Parliament? Then sorry, we'll give you the adopted and endorsed document. Now, in that document, you will see, say, Alban Bagbin ruled on what we call 4 MPs and not 3 MPs. Now, that's fine. Now, Alban Bagbin's lawyer feels sorry. And so he raised another issue. He raised an issue one of the judges are not Okapano or a former NPP parliamentary candidate. Jesus Christ. Judge ana otesono ono ebebua semno or a former parliamentary candidate wejinama MPP waye serial caller da waje card da ena eye Alban Bagbin lawyer na erezi issue ni say Madam Judge, your colleague sitting there, even though he is a judge of the Supreme Court, he needs to recuse himself. Because Alban Bagbin application say the judge na otowono eye gawuno se de na friend sano. He is a member of the NPP. Now, may I explain it bibi acho? Momianko tie the Chief Justice ne kind the response. Na menchira wadebi. This was the response of the Chief Justice.
Rises from some
so that my lord for the extreme what?
Right to my lord the Chief Justice. To him being impaneled in this matter arises from the fact that at the point in time he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings.
said no. I think you said enough. Kindly resume this.
Very well. And in fact, it was
Parliamentary na MP say 9. Omo wasem enema Alban Bagbin take a decision or take into what will make the Supreme Court take half truth and try to judge or make a ruling on half truth, because you cannot go to court with half truth. And when you go to Parliamentary, you will see this. I'm trying to get you everything. Moma yankonko tie the Chief Justice and the Supreme Court timer Speaker of Parliament the lawyer Kasaye.
And so that was taken into account before the court makes the extensive orders relating to even 4 parliamentarians when the writ itself affected 3 parliamentarians. It didn't even include Article 97, 1 each. And so all of those orders were made based on some of those findings. And I'm saying that, and the position is that the first defendant, based on these things, expects that in order not, especially when the court reaches the conclusion that on the balance, there was no balance, there was just one side of it, because it was an ex-party application, and they were heard. What was the balancing?
Sorry.
Yes.
I thought you were just responding to a very straightforward.
Oh, yes.
But now the case that we are hearing into the substance of the motion itself, I would urge you rather to restrict yourself to the objection that and answer it, whether it is scandalous or it's not scandalous.
This is not scandalous.
My problem is
yes.
If your learned friend on the other side has raised these matters and you think it's not scandalous, you don't have to, as it were now, veer into the substance of the application itself.
My Lord, I needed to demonstrate that these things were not just said out of any.
Just restrict yourself.
My Lord, I thought I was doing that. And so, as far as I'm concerned, apart from the use of the word scandalous, which he just used, he doesn't demonstrate how scandalous it is based on the context of the application that I have before.
We allege that the Chief Justice is privy breach of a constitutional provision. What are you trying to convey?
It may have been by reason of evidence. But if that's a statement of facts,
was it necessary for you to add that in your depositions for you?
Abusuya mo kwa basado over daily update TV. So then I'll show you Medina na subscribe to my YouTube channel no. Subscribe you and no like or share. Now the commenting so I share you Medina sin. Ebaje brena ya kameti for na hwefo nyina so atimi. Na ensam no ene ebo ne tofa no. Supreme Court versus Speaker and I say the Parliament of Ghana. Ni nyina ye ensam a che say More train so dare we see we de nyinaa yɛ ɛyɛ asɛm a speaker den akɔkaeɛ anaasɛ seat a ɔkɔ declare vacant ɛno na de saa mentimi ho ase wei nyinaa yɛ den ɛbaa abusua ayɛ daily update so then I will share and subscribe because over according to Kelvin Taylor in seminary source or kazano over the expertise applications era Afenyo de coin na applications be endorsed wasi asɛm no krampo no esi no any expert no de coin ni nyina kyerɛ ensɛm no ɛyɛ nsɛm bi a ɔmo di ho nkɔmɔ no kora ɔmo nwie yo ɛna Afenyo fa asɛm no ɛde kɔ nti no hwɛ a speaker kora declare 4 seat Afenyo mark nso say ɛyɛ 3 seat abusua that is a which is which why ɛna ɛka no kora abusua ensɛm no ma me information a na nkɔfa asɛm foforo ɛnyɛ dɛ ɛmɛsum ayɛ daily update TV so God bless you.